If you want to protect your business or brand with a trademark, then you need to know the steps to do so. And the fourth step in the trademark process is to negotiate with the government. And that's exactly what we're going to be talking about in today's video. Hi, I'm social media attorney Ethan Wall, and I'm here to talk to you about the fourth step in the trademark process, how to negotiate with the government. You see, to get a trademark, you already have to go through the first three steps. Pick the perfect name, run a trademark clearance search, and file that trademark application with the US government. But what happens next? You sit and you wait. Yeah, really. Once you file your application, the government is not going to review it for about 3 to 6 months. Pre-pandemic, it would take about 3.5 months for them to get back to you on your application. Since that time, it's been about 5.5 to 6 months, so you have to sit and wait. And at that point, the government is going to do one of two things. Either A, see that you met the legal requirements and that there's nobody else out there using it as far as they can determine from a trademark search and preliminarily approve your application. Or B, they're going to reject you just like, I don't know, swiping on Tinder and getting rejected by somebody with something called an office action. An office action is where the US Trademark Office take some sort of action against you to deny your trademark application. And at that point, you have to begin rolling up your sleeves and negotiating with the government. Here's how the process works. First, you review the office action to see what are the grounds for the denial. Sometimes the grounds are going to be simple and something you can easily fix through a mild negotiation with the government, such as changing the description of how you have described your logo. Or perhaps you might have to change the name or spelling of certain things, or adjust the amount or volume of goods and services that you applied for. These types of things can be handled through a friendly negotiation with the government, coming on the same page, reaching an agreement, and your application moves on. But sometimes the office action denies you for a serious reason, such as a likelihood of confusion with someone else's trademark or a prior filed trademark application. At that point, you need to use your legal analysis to determine your likelihood of success, the best strategy to do so, and likely file some legal briefing or paperwork or an appeal with the government in order for that negotiation to move forward. So as you can see, the negotiation process with the government is so very important. Once you get over that hurdle, then your trademark is going to be published for opposition, meaning other people have the chance to object, and assuming that no one objects, you are in line to get a US registered trademark certificate, but only after about a year of negotiation with the government through that process. Having watched this video, you now know of what to expect, and you may be able to hand those negotiations with the government and do it perfectly. But mistakes can happen, and what you say and do in these negotiations can be used against you if you make a mistake and have to file your application again in the future. So it's important that you do it right. Here at the Social Media Law Firm, we've negotiated over 200 trademark applications for our clients and even for our law firm. So we're pretty familiar with the process, and we'd be happy to help you too. Just contact us today here at the Social Media Law Firm to see if you need help with filing your next trademark application and having a successful negotiation with the US Trademark Office.